Welcome to a special episode of the Georgia Politics Podcast. I am your host, Preston Thompson. Today we've got a wonderful interview with Representative Josh McLaurin. He represents the Johns Creek, Sandy Springs area, right near where Appen Media Group is based. Representative McLaurin, thank you for joining us this morning.
Thank you, Preston. I'm really happy to be here.
So to open up, tell our listeners a little bit about your private life, what you do in your real job, and then what inspired you to get involved in our citizen legislature here.
Well, I consider both real jobs, Preston.
I'm sorry. Yeah.
No problem. But yes, I'm an attorney. I grew up in Georgia. I grew up in East Cobb, actually, and commuted inside the perimeter for school. Went to UGA, went to Yale Law School after that, and then came back and basically started practicing law in Atlanta. I did do 1 year in New York, and you might have seen some campaign mail about that. But I've been a lawyer my whole career so far, and I do civil litigation at the law firm Crevlin & Horst. State Senator Zara Karenchak is a partner at that firm, and so we enjoy the camaraderie that comes with wearing two hats, and they happen to be the same
Been a
hats.
successful firm for Democratic politics, yeah.
Well, and we kind of popped up out of nowhere, which has been fun. So, let's not say nowhere for the law side of it. The politics side, we came out of nowhere. But yeah, and so Atlanta to me is such an interesting opportunity for growth in a lot of ways. I mean, I love being here because from a law practice perspective, it's an interesting market, but the metro Atlanta area has so many challenges, and I'm sure we're going to talk about some of this stuff, that I think we have a unique opportunity to solve. The issues like affordable housing, what we're going to do about schools in this state. There's a big conversation about choice versus making sure public schools are well funded. I just think that Atlanta has the variables, kind of the ingredients that we need to build a future that could work in a lot of different places. And so I hope that I get enough time off from my law practice to really spend time thinking about these issues over the next few years. And I trust that I will. I have a policy background as well from UGA. I went to UGA for a master's in public administration, and I was hoping when I jumped into law school that I wouldn't miss out on an opportunity to come back to that policy training. And so here we are. We're doing the good work.
So was there a moment, or was it just sort of always in your mind of wanting to get more involved in politics or public policy, or has this always been a goal, or was there kind of a genesis moment of now I want to do this, I want to run?
Well, I can't say I always wanted to run for office, although whenever somebody says that, you always feel like they're lying, right? People who say, oh, I'm not going to run for that seat. But for me, I really did not expect to get involved in politics per se, to actually run for office myself. And the reason for that is I considered myself sort of a wonk. I mean, I went to policy school. I thought I'd be somebody, maybe I'd work for a politician, or maybe I would work for a nonprofit that did policy work, or practice law, right? I didn't expect actually to be in this role. And when President Trump won in 2016, and this is what I tell folks from both parties, I feel like everybody had to recognize at that point that if you want the world to look a certain way, that you have to be proactive yourself about making sure that happens. And you can't just leave the condition of your democracy or the issues that I was mentioning just a moment ago to somebody else and then turn around and say, well, I wish it looked differently. And in a very direct way, I guess running for office is an answer to that. There are lots of ways, obviously, to get involved. But for me, in 2016, when I saw the way that the election transpired, I thought, I'd like the world to look differently than the vision that I'm seeing right now. And I've got, law school networks. I've got networks from UGA that would be able to support me if I tried to do this. And it just seemed like the right thing to do with those resources.
You're one of a sizable handful of newly elected Democrats from the 18 cycle. You have a half of a legislative session under your belt. I'm assuming in the fall you're hoping to run again next year. Okay. Yes.
I'm nodding my head. Right.
Okay.
Yeah.
So I'm assuming in the fall you're going to be making the pitch at least a little bit, and then next year making the pitch a lot harder of why you deserve to have your seat back. I'm curious, as a member of the minority party, that we can get into why your bills aren't coming to the floor or your colleagues' bills aren't coming to the floor. What's your pitch to voters of why it's important to put you back there and what sort of difference you've been able to make?
Sure. Well, I don't want to get too fuzzy here with the metaphor. Hopefully this makes sense. But when you look at a piece of art, you look at a painting, it's got both the subject or the focus of the painting and it's got negative space. And both work together to create an image, right? And I think it would be unfortunate if the mail that you're going to get in a campaign sums up the whole conversation about two candidates in a race, because the mail you're going to see about me in 2020 is, well, he didn't do anything, right? He didn't pass any bills, which, by the way, is not true, because my name has been one of the co-sponsors on some bills that have passed. But he wasn't lead sponsor. He didn't have the relationships with the majority and the people who are getting things done that the opposition will have. Well, and to your point, which you're suggesting, the response to that is the minority party has a different role than the majority party. The majority party's role is to basically have the state's interests in trust to carry them through and to act on the state's business. And the minority party's role is to guide the majority party in doing that. And you actually, even when you like the majority party, you still want a strong minority party. Because if you don't have one, the majority party is unaccountable. I mean, I'll make a legal analogy. In a court system, we rely on adversaries. We have what's called an adversarial system to find the truth. That's why we pit parties against each other in a case, because we want the judge wants to be able to have the best, means of finding the truth at her disposal. And the way that she does that is she says, you guys fight it out, and I'll decide who's right based on that competitive energy. And the same thing is true, I think, of the state house. So it's just totally shallow to say that the minority party is not doing any work because the minority party doesn't have its name stamped on as many bills. And in some cases, when the majority party goes so far off the rails that they pass legislation that would worsen our, nation-leading maternal mortality problem, and make us a target for, make us ashamed, make us a target for criticism throughout the entire country. There would be an assault on women's bodies, their fundamental rights. At some point, the majority party maybe shouldn't be trusted to lead. And then you have a conversation about whether the minority party should become the majority party. But especially at that point, you have to realize that sending somebody like me back means another step towards making sure that the people who have gone off the rails, who have been entrusted with our state, who shouldn't be trusted with our state, no longer have that trust. So, that's an elaborate way of saying vote blue in 2020. And, hopefully we'll stop bills like the so-called heartbeat bill or forced birth bill. But I think the larger point is this is why we vote for people based on their values, because to be represented, it doesn't just mean that you're like a factory that's, stamping a bunch of bills and, just tinkering with things. The expression, if it ain't broke, don't fix it. You can't evaluate success purely based on the number of changes you make to something. You want to evaluate success based on where your heart is, what your vision is for, and whether you trust somebody to, when they get power, to push in the direction that you want.
You mentioned HB 481. We've heard a lot of arguments from Democrats against that bill. I have a hard time thinking of another legislator that has more legal arguments against it than I heard come from you. And what you stuck to, I believe, on your speech on the floor was the personhood element of it and why that created legal problems. So give us a run through of where you were coming from for that, and if you think that's going to come up in the future in the court system, if that was there just for the court system, or what you think.
So just to be clear, I actually didn't speak on 481 from the floor, but I have written about it, like I've tweeted, and also got interviewed about it. But you're right, I have made an argument about what I think 481 does, and let's back up. I think maybe just a minute. This is going to turn into a law school class here in a second. I apologize.
That's okay. I'm ready. I brought my books.
So let me give a quick breakdown of why the conversation on 481 was a little different, maybe even from other states this go around, but also from previous conversations about regulating abortion in the United States. Going back to Roe v. Wade, the justice who wrote that majority opinion, right, that established what we call a substantive due process right to get an abortion. What he wrote in the opinion was that if the fetus's right to life is established, then we don't have the rest of the discussion about whether a woman has a right to an abortion, because obviously the fetus would have a complete right to life under the 14th Amendment, and you couldn't abort a fetus, to put it quite bluntly, because the 14th Amendment would protect that fetus. Now, just to be clear, that's a different thing than talking about whether a woman has a right, because again, the justice was talking about the fetus's right. Now, a lot of folks don't talk about that part of Roe, because the what usually gets the focus is the woman's right to choose, right? That's what the legal effect of Roe is considered to be. Well, what the majority did in the state house was attack this problem a little differently. They said, well, everybody's talking about a woman's right to choose, and that woman's right to choose hinges on the viability of the fetus, as case law made clear. Well, what if we focus on this other excerpt from Roe that says, what if the fetus's right to life or right to personhood was established? And the reason the word personhood matters is because the 14th Amendment says person, right? And so the idea was, what if we build a bill that shows just how much Georgia recognizes a fetus as a person? Because if we do that, maybe we can put the secret key in some lock that solves this constitutional problem we, the majority, have. And what we can do is basically, I guess, convince the Supreme Court or convince the world at large, look, in Georgia, we really do consider a fetus to be a person in all relevant respects. That's why the bill, creates a right to child support at 6 weeks, or it includes fetuses in population counts, right? And uses very flowery language to say, full personhood in the preface to the bill, right? That was the purpose of that, because they felt like they had this legal trick, for lack of a better word, to get around the current case law on abortion, and to basically have a new angle at outlawing it. The problem with that is that legal argument is dead on arrival. It's a bad argument. And the reason it's a bad argument is because of something called the Supremacy Clause in the United States Constitution, which says federal law is supreme to state law. So just because Georgia knocks on the door of federal courts and says, hey, we've decided that this, fetus means person, doesn't mean that federal courts have to accept that definition, right? Because in the very same opinion, the justice who wrote it in the next paragraph says, well, guess what? We're deciding that a fetus is not a person for the purposes of the 14th Amendment. So Georgia's bill, Representative Setzler's bill to try to act like a fetus is a person in all relevant respects, that might be true for Georgia law, but you can't overturn federal constitutional law just by passing a bill like that. And so that was the flaw in their argument. But I'll say one last thing, because I've been going on for a while. One thing that Democrats didn't do well is recognize that was the argument that Ed Setzler and the rest of the majority were making. And so Democrats got arrogant a little bit. We thought, hey, we know this argument. We've seen this movie 100 times. This is unconstitutional, and you guys have no idea what you're doing, because look, this is the same argument that's been tried and failed. And I think the majority was able to look at us with some side eye and say, actually, we're making a different argument this time. It doesn't matter that it's a terrible argument that a lawyer could disprove easily, but the fact that we didn't really know exactly what they were saying, I think gave them the confidence to go to their base, to go to the media and say, we've got this brand new approach to trying to solve the abortion rights problem from our perspective, right? And the Democrats just don't even know what we're doing. They're not playing on our level. So that's not to say we weren't playing on their level. It's just to say this is yet another reason why precision, really listening to the other side and understanding what type of argument they're making so that you can respond is so important. Because then it gives you credibility. Once you're able to frame it up correctly, then you can have a real debate. But before that, you're just sort of talking past each other.
So the benchmark for, them drawing this line moved from 20 weeks, I believe, to 6 weeks.
Right.
In a hypothetical world where that could be undone, is 20 weeks, in your mind as a legislator who has a vote on this, is that the correct standard by which we should be governing, or do you think it needs to be moved beyond where it was when you came into the legislature?
20 weeks is already a compromise, and I put quotes around compromise position. For one thing, it's not the constitutional standard. It's just not. The standard established by Supreme Court case law is viability. And a state cannot stipulate, for the same reasons I just said, about how a state can't decide what the standards are in place of the Supreme Court. A state can't decide that 20 weeks is constitutional. if, maybe you could go to court and show that viability is always at 20 weeks, but you can't. Well, I mean, theoretically, you could say, well, what if 20 weeks meets the viability standard? But categorically, it can't, because that's the purpose of having a viability standard, is that, it might be different in different cases. And so states really only have the ability under constitutional law to regulate up to viability, and that's it. So I'll put it to you this way. I'm not a doctor, and I'm also not a woman, and I can't sit here and tell you, in terms of right or wrong from a moral perspective, this is exactly where the line should be. What I can tell you as an attorney is exactly where the line is, and that's viability. And so I would prefer, more often than not, hopefully all the time, that Georgia would follow constitutional law and just do what the lawful thing is, rather than try to legislate morality, make up its own rules.
Let's stay in law class for
Sure.
a little bit.
I'm comfortable there. So thanks.
Going to an issue where you did actually speak on the floor. I got that wrong the first time. Senate Bill 77, which was a monument protection bill. We can get into the naming of it if you want. You were again outspoken on the legal aspect of it, and it was one of my takeaways watching several days of session, of hearing you say, in this law, either everybody can sue or nobody can sue.
Right.
And that's not the way we should write things.
Right.
That, I think, is a tough point for people at home to understand when they're hearing arguments on the floor from Representative Powell and some others about this is just protecting our history. So Senate Bill 77 took some lengths to protect monuments, saying you couldn't move them unless you're moving them to a place of more prominence. And the bill's author said it was to prevent defacing monuments from all wars, but I think Democrats honed in on Confederate monuments because it is the topic of the day. So
Right.
Run us through what your argument against this bill was that is now signed into law, and what kind of challenges could come up from it.
Yeah, and it's so nuts that it's actually law now. I mean, I'll, without naming names, every now and then I'll text with another member of the Democratic caucus, like if there's some news article about accidental damage to a, like there were statues at the historic statues at the governor's mansion, right, that were damaged. And, why isn't that a lawsuit? Because even if it's accidental, the bill didn't distinguish between whether there was accidental damage to a monument versus intentional, right, or like malicious somehow. And so we were reckless as a legislature in passing that bill. So I'll get to the point. What the bill does is it adds, or what it did was it added a what's called a private cause of action, basically just the right to bring a lawsuit to the Georgia Code for 3 times the amount of damage that is caused to a monument. And a monument's very broadly defined, and this is one of the reasons there's so many opportunities to text your friends about potential lawsuits you can maybe jump on. But it's defined to include, I think, like names on public buildings. And so even if you rename something, that could potentially give liability, because what they don't want is, you've got like a Robert E. Lee Center for, like a library or something. And if a local jurisdiction decides to rename it, maybe they'd be subject to liability, right, because of erasing history or whatever the rationale is. So what actually, I should back up. There's already misdemeanor liability. So if you are a local jurisdiction, you're like Decatur, and you want to take down that obelisk in your square that is a monument to Confederate soldiers, I believe it's already a misdemeanor, or already would have been, to for the city to take that down. But there wasn't a civil remedy, right? A misdemeanor is a criminal remedy. There wasn't a civil, money-based, for lack of a better word, option to try to punish or deter people from messing with those monuments. So again, 3 times the amount of repair costs plus punitive damages, which a jury just kind of makes up, right? Plus potential, costs, attorney's fees that go with litigation. So, the nightmare scenario here is, because you don't have to try to do it, right? Your car runs off the road and you accidentally hit a monument. And that, let's say it would hypothetically cost $100,000 to replace that monument. So now you're on the hook for $300,000 in terms of the repair costs. Plus, if the jury gets really mad because it's a really valuable monument, maybe another $200,000, let's say, in punitive damages, plus attorney's fees, whatever. I mean, you could be on the hook for $500,000 for a mistake, because again, it's not about whether you intended to do it. But here's the real issue. The real issue is that, and I tried to explain this from the floor, but I only had 5 minutes. It was kind of tough. In the American judicial system, You can't sue people when you're not personally injured. And this makes sense, right? You think about when somebody brings a lawsuit, if I'm in a car accident and I get hurt, I can sue. But if I see a car accident on the road on my way to work, I can't go into court and sue for the medical expenses of the person who I saw get in the accident. I mean, number one, you never heard of that. It doesn't make any sense, right? And then you start thinking, well, who wouldn't be able to sue if you could just see a car accident and go sue for the medical expenses and then pocket them personally, by the way. You don't give them to them, or maybe you give them just enough for them to get treated, but if you happen to recover more, you get to keep it yourself. That's basically the system that this sets up with respect to monuments. So if I'm that, sad driver who ran off the road and hit a monument and 5 people happen to see it, they could all go to court and file the exact same complaint to recover 3 times damages, punitives, whatever. And then there's just no work whatsoever done by the committees, this bill, whatever, to explain how that works, right? So if 5 people file identical lawsuits, do they have to split the 3 times pro rata? Do they all get 3 times damages? What really is the limit? And what Chairman Powell said is, well, standing would limit it. And what he's referring to is a principle called standing, which says that you can't bring unless you are personally injured. You can't bring the lawsuit. So you have to be somehow affected personally. But how are you going to be uniquely affected in a world, where everybody could claim the same moral offense? And the point is that in the American system, moral offense is not enough, right? Like, just because I'm offended by somebody damaging a monument doesn't mean that I've been injured in a way where courts will say you have standing, you have the ability to sue for this. So that's all the explanation for why it's everything or nothing. I mean, essentially, if you have standing to sue because you're offended by damage to a monument, everybody does. We could all go to court, file the same lawsuit. But if you really don't have standing, which is probably the truth, is that nobody really has the ability to sue for watching the thing happen, then you've created a completely ineffective remedy that does nothing. It's just political posturing. But guess what? That's exactly what the majority wanted. The majority wanted a bill that didn't actually really do anything, but looked like they were being tough on people who wanted to take down Confederate monuments. So it's pure politics.
Does the bill circumvent the ability of local governments if, the city of Clarkston had a monument that the city council voted to remove?
Yes.
So they would effectively, if it went that way, get engaged in a suit with the state government.
Well, so it wouldn't be a suit with the state government, it'd be a suit with anybody, right? So that's the scenario, right? Let's assume Decatur wanted to take down that monument in their square. Decatur would be liable because Decatur is covered as one of the persons who's not allowed to do this. So local jurisdictions are not allowed to remove Confederate tributes to Confederate, soldiers or the government or, the country, whatever. And would be subject to liability. So again, if I'm a citizen of Decatur who doesn't like that Decatur is thinking about removing, and I don't know if they are, I'm just saying, hypothetically,
Sure.
if they were, and I were a citizen who was offended by that, I could sue the city of Decatur for 3 times the replacement cost of the monument, which is why Decatur won't do it, regardless of whether this technical legal argument would succeed in court. I mean, obviously I get pretty hopped up about, what you would say in court about this, but if you're a council person in Decatur, it'd be political malpractice to, it's bad leadership in the face of a bill like this to subject your city to that kind of liability. So that is a real effect. When I say it does nothing, I mean, technically, legally, it probably does nothing, but the effect it has is to further chill local jurisdictions from making their own decisions about what types of messages their community is sending. I mean, it's bonkers.
Okay, out of law class for a little bit.
Yeah, let's leave. That was a lot. I apologize.
No, I enjoy it. When people watch the news at night and look at gridlock in Washington, it's really frustrating, especially in situations we had with the disaster aid relief not getting here fast enough. As a local legislator, would you tell those people that Georgia in the Georgia Capitol is better? Would you tell them you're not experiencing the same problems? What kind of differences do you think there are between those two things, and maybe where people can find some hope in their local legislator?
I'll give you 3 answers, and they're going to be on a spectrum from cynical to aspirational, and then the middle answer is just kind of wishy-washy both ways. I'll start with the most cynical answer. The most cynical answer is we have fewer cameras pointed at us. And so we have less of an opportunity than politicians in Washington do to posture and to get in front of the camera and act like we're so tough on this issue or so tough on this issue. And I think that makes sense to a lot of people, right? Well, yeah, if you gave us more rope, we're politicians, we'd use it, and we would try to even further polarize and divide our base or our constituents into categories, so that it would make it easier to lock down our political support. I mean, that's not that I want to do that. I'm just saying I think that's how politicians behave from just a game theory perspective. And if we had more cameras, I think we'd be more susceptible to that. The middle answer, sort of wishy-washy both ways, is, maybe that's true, but also Georgia lags behind the national political environment in terms of party dynamics, right? Because Georgia had a strong Democratic majority until the 90s, right? And then it officially flipped in the early 2000s over to Republican control. But we've been lagging behind the national political shift for some time. And so the fact that there's a little bit of a mismatch between Washington and Georgia in terms of what it means to be a Democrat or a Republican means that we also have a little more leeway in that sense to define ourselves, to be expressive, to build relationships across the aisle, because, if somebody in the majority party looks at us and the way that we behave and they think, well, that's not exactly the same as a Democrat in Washington. So I can work with these Democrats, right? Mm-hmm. Now moving to the aspirational answer. I'm from Georgia, and I really love it here. And I think that there is a type of Southern hospitality that we all know. I mean, that's maybe a cliche phrase, but by living here, we're all familiar with the fact that people are friendly, that you can talk to just about anybody, and that there's something about, again, going back to what I said about the ingredients of Metro Atlanta. Metro Atlanta is considered to be a really liberal part of the state, but in a lot of ways, Metro Atlanta is a mix of so many different perspectives. I mean, in Forsyth County, up in Milton, you have, Milton and Fulton County, then up into Forsyth County, you have practically rural areas, right, with sprawling properties and the types of values that mainstream Republicans really like to appeal to. Really valuable culture that we don't want to lose in some cases, right? I mean, there are aspects of a culture that's more rural that obviously Democrats have an issue with, to the extent that it has to do with inclusiveness, diversity, or certain types of modern ways of thinking about economics. But no, it's beautiful country, and it's right on the doorstep of in-town Atlanta. So in my opinion, I think Atlanta does such a good job of diversity, and not just racial diversity, gender diversity, et cetera, but political or partisan diversity. And so, this whole narrative about going to the rural parts of the state in order to shore up support because you can't get in Metro Atlanta, I think there's a lot to that, obviously, but I don't think that necessarily means going to a different part of the state, from this homogenous. No. I think that there's so much going on in Metro Atlanta that really, and this is something maybe rural voters might want to hear, I think rural representatives from those areas are much more culturally Metro Atlanta, because they have to live and work within a medium of diversity while they're at the Capitol and while they're compromising than they have to when they're at home. So I guess my answer to Washington, or what's the comparison between us and Washington, would be, I think we have such a rich climate for figuring out how to do politics well, and it's an opportunity that we're going to get tripped up on if we keep doing stuff like, I know I keep coming back to HB 481 or SB 77, but if we use our majorities to do stuff like that, we're going to waste the opportunity that we have to build a new collegiality for this century, I think.
So you mentioned it at the top of the show. You were engaged in a suit during your 2018 campaign over a mailer that came out from your opponent that claimed any number of things, and we can get into those if you want.
Sure.
But in researching that and looking at the mailer more, I thought it raised a really interesting question looking back on how we're running campaigns, especially at the local level. I saw a lot of mailers go out with Nancy Pelosi and Mitch McConnell on them, much more than I did with the actual candidate candidate's face or their reputation. So I'm curious if you have any thoughts going through that experience about what we can do to, make sure that the way we're running elections doesn't have a lasting impact on voters' perception of their opposition party, whether their vote goes to the winner or the loser.
That's a great question. I mean, one of the things about that libel suit, so I sued the state Republican Party for libel because in a bunch of mailers to my neighbors, they made the statement that I was under criminal investigation. Well, the reality was that the state GOP had hired attorneys to file complaints with administrative agencies, not criminal investigative agencies, but administrative ones like the Secretary of State or the Ethics Board against me. And then after they themselves filed those complaints, they turned around and sent mail saying I was under investigation for whatever the stuff is that they alleged. And nothing has happened with those complaints yet formally, right? It's all their project that they designed. And so the mail said, like I say, criminal investigation. Well, a libel suit's not available to everybody because politics is tough, and you get to say quite a bit of stuff before you actually are on the hook for libel. So it's not like we can all just breathe easy because we can bring a libel suit in case we ever get in trouble in politics. It's just not how it is. These were totally rare, exceptional circumstances. And that's kind of why it was so crazy is they screwed up so bad that they actually were on the hook for libel and settled within 2 weeks, right? I mean, that's how nuts it was. So just kind of using that as a starting point, we don't actually really have a lot of tools that where you can force somebody to behave a certain way in a political campaign. And I'll drag you back into law school for just a minute. There's a rule called prior restraint, or there's an idea called prior restraint in First Amendment law, which is this idea that you can sort of regulate speech before it goes out. You can't. The prior restraint is highly disfavored under the First Amendment because in general, we'd rather not restrict speech because that tends toward a more totalitarian environment. We would rather answer bad speech with good speech. That's our, even if it's costly, even if it's unlikely that the little guy always gets a chance to be heard, we would much rather allow all the speech to happen and then hopefully voters will sort it out. And here's what I'll say. I really believe that works. I talk to people who are Republicans, so not my party, who are my constituents during the cycle, during the campaign, who said, I just wish people would not snipe at each other, not take these pot shots and would talk about what they're going to do and not rip on the other guy all the time. People are sick of uncivil politics. And so I think that those mailers probably backfired. I think a lot of people got them and said, what is this trash? I hate this. This is not how I'm going to decide who I'm voting for. It just seems like this is desperate. It seems like this is not coming from a good place. So that's the first thing I'll say is people are incredibly smart. People get mail. People are not like these automatons that people planning their mail programs in back rooms think they are. Oh, they're going to really love this part of the mail. No, human beings get home from their complicated jobs that they have advanced degrees to do, and they get this like trash political mail in their inboxes, and they say, well, if they even look at it, they say, what is this? And so I think one thing we can all do is relax just a little bit about what we think, for example, mailers are doing or TV ads are doing, because people have their own reactions. But I think the real problem with all of that is that people get exhausted and people lose faith that we can really talk to each other anymore. So it's not like there's the whole like Russian bots, people, click on a link and think that it's true no matter what. That phenomenon is real in this country. But I tell you what, it's not as real in House District 51. We have a highly educated district of folks who know what's going on and can evaluate messages. So I think the real cost is, well, what if politics will never be different from this? What value is there in engaging in politics if it's just going to be these trash messages that make me feel bad and that pit human beings against each other and make us all hate each other? Why would I want to get involved in something like that? And you know what? That's a really good question. And I think for a lot of people whose lives are pretty okay and don't feel like they need to go to the state house to solve their problems, the best, most rational solution for some of those folks is probably just to check out. Because I tell you what, it feels bad for, you've been down at the state house. It feels bad when things are super partisan and super charged. And so I guess, is there an easy answer to that? No. What I would hope is that we all have courage to think about politics in terms of how we can connect with people more instead of how can we win, how can we push through our agenda, how can we be powerful. I think the real question to ask is how can we have fun, how can we engage with people who are both like us and not like us, and build the most surprising and interesting and satisfying coalition that we can to express who we are and to get stuff done. That attitude, I think, is the answer.
There's a section of your party though it's very vocal. It may not be the biggest section, but it's very vocal, especially on issues like House Bill 481. And when they come down and protest at the Capitol, they say this is not a game anymore. This is a big decision that they made. And they hear an answer like that and they say, now is not the time to ease up on the rhetoric. Now is the time to double down. Like now is the time to go after it. Is there a line, or is there something that you think there's a responsibility of politicians to hold back a little bit and say, no, this is still something we can work with the opposition party on. We can still work with these people to get something done.
Well, I think you've asked two different questions in the last two, right? The first question was about not necessarily political mail per se, but messaging and campaigns and, the negativity in politics, right? And what you're talking about now is a much different question. I just want to be clear. You're asking, how do we respond to terrible legislative initiatives that threaten millions of people? And in that context, there's only one option, and that is to hold the line, be vocal, never take it lying down, and fight hard, back as much as possible. That sounds contradictory because it's like one seems collegial and one seems like fighting, but I think they go hand in hand. The idea of building a coalition that is interesting and fun and is expressive and gets stuff done is to listen to everybody in the coalition and to truly take people's needs to heart and to feel compassion, true compassion for people, right? It is my conviction that when you do that and you listen to women who are speaking up about 481, there is no other conclusion except to completely hold the line, to say, no, this is dramatically terrible bill, the worst that we've passed or are considering in recent memory, that people should lose their seats over. People should go home because of it, right? So it's kind of, you've identified this problem, which is how do you work with somebody when they're doing something that you think is monstrous, right? And I think the answer is just like every moment changes context, like, we're at lunch and we're talking, we're chatting, we're eating, we get our bill, we leave, we wave bye. There's a moment for everything, right? There's a moment for shaking somebody's hand and expressing a genuine desire to work with them. And then there's a moment for blocking what they're doing and going to the mat to make sure that they don't even come back to the state house. And so those moments sometimes don't happen at the same time. And then when those moments when they overlap, like for example, if my constituents see me in the same room as Representative Setzler, who is the architect of the heartbeat bill, but he's, somebody who works with me on the Judiciary Non-Civil Committee. Yeah, that's a difficult balance because, what am I going to do? Like pal around with him and joke around in front of people whose lives they feel like he's destroying in some ways? I can't do that. And so you're right that there is in order to be a true representative of what my constituents feel and what they want, I have to be careful about how much cooperation I really can engage in certain moments, because, well, you forced my hand. I would be your friend, but you have decided to do this thing that's going to hurt so many people that you have changed our relationship by doing that.
All right, before I let you go, I've got to ask if you have a favorite in the presidential primary. If you don't have a favorite, any particular thoughts or anything like that, because I know you might not be ready to come out and pick one of the 62 candidates declared for president.
Well, I really hope that the lesson that people draw from 2016 is not that a woman can't win or that people aren't ready for a woman president. I think that'd be the most backwards, wrong-headed conclusion you could possibly draw from 2016. In some ways, I feel like it's awkward for me even to run for office. I remember asking, the women's group, No Safe Seats up in North Atlanta, does it even make sense for me to run? I mean, this is the year of the woman in 2018. I don't want to get in anybody's way when it's time for new, fresh voices and faces. And the response I got was, we need all hands on deck, right? And so if there's not somebody for a role and we need somebody to step up, then please step up. Well, like, we have a couple people who are willing to step up for the presidency of the United States. So, given that reality, what's that hashtag? It's "Can you not?" Have you heard of this?
Mm-hmm.
Which is, can you not? The missive to white men who, as Stacey Evans once put it in a speech I heard, look in the mirror every morning and say, "Looking at the president." I guess, my general attitude towards the primary is I don't think we should worry about who's electable. I think we should worry about who articulates the best policies and who has the most passion. I think the debates were instructive as to who is most likely to meet those criteria. And I look forward to seeing it play out. I mean, I think I've only met, I had an opportunity to meet Beto and Kamala Harris. They're both super impressive. But that's the thing. It's like you've got a lot of folks who are very impressive, who are very genuinely nice and want this country to be on the right track. And so we just got to see what people want.
Do you have a particular affinity for the lawyers or the legal minds, the former attorney generals or attorneys general?
Just because if I don't know you, then I don't necessarily like you more because you're a lawyer. I think that there in general should be more lawyers serving. Because kind of some of the topics we've been talking about, that it's important to be able to look critically at legislation and, see beyond just the surface level politics of it. But no, I would say I think everybody's got valuable experience. I mean, I really enjoy that Senator Harris is a former prosecutor, because I think it gives her perspective on a really important issue, mass incarceration and the criminal justice system. And I think she's got perspective on that it would be hard to have without. And that's not, again, endorsement. It's just to say that I think that everybody's got that type of interesting perspective.
Sure.
Yeah.
Representative Josh McLaurin, he represents parts of Johns Creek, Sandy Springs, and Roswell.
Yeah, that's right.
Thank you for coming on this morning. I hope our listeners will enjoy this episode. This has been a special episode of the Georgia Politics Podcast. We will talk to everybody next week.
Thank you.